been a while. Thank you. Thank you. All right, Mr. Blackburn, you have our undivided attention.
Thank you, Your Honor. Gary Blackburn of the Nashville Bar. On behalf of the appellants, I'd like to reserve 3 minutes.
3 minutes, yes, sir.
Your Honor. Please, the court, there's a substantial bit of evidence in this record, which I don't believe I can touch entirely in 15 minutes. Perhaps don't need to. But I think what's important to understand is that this case contained an initial complaint that alleged defamation and also other common law torts, including intentional infliction of emotional distress. The fact pattern arose out of a long-standing dispute, I'll call it, between the mother and the daughter. The daughter, Gracie, was described by her mother as being very difficult. This finally culminated in physical violence. Gracie has said that the police were called 12 times to their home. Ms. Baldwin says 6 times. But at any rate, the child left and went to the home of another person, and a few days later went to the appellant's home because they had a daughter who was a school friend of Gracie. Everything else sort of arose out of that. Ms. Baldwin described her daughter as being unworthy of belief, someone who had lied under oath, who was willing to lie under oath in a legal proceeding. Whether that's true or not, I'm not taking a position today, but that she did so testify. The reason that's important is that Gracie was a plaintiff when the case was originally filed. It was filed under a sworn complaint, verified complaint. She later withdrew from it. Then she later gave another declaration in this instance in which she affirmed all the things that she had said before and said that the statement she had submitted saying that these things weren't true was something she had never read. At any rate, she's no longer a plaintiff and therefore not an appellant. The reason this is important is because there would have to be, with the comments that were made on TikTok over a 2-year period, some of this information would have to be supported by testimony. None of the things that Ms. Baldwin alleged on these hateful TikTok videos has any support whatever from anyone other than her in hearsay. So it is difficult to understand how these facts could not at least create a question of fact as to whether defamation has occurred, if we just focus on the defamation. Ms. Baldwin alleged that my clients were kidnappers, that she had a frightening story to tell, that she wants to warn other parents about Ms. Black and her husband, that Mr. Dozier was inappropriately fixated on Gracie. Her proof of that was, she said repeatedly that Gracie was forced to climb up in Mr. Dozier's bed for prayer. Ms. Baldwin admits she didn't see this. Mr. Dozier says that's not correct at all, and there's no other proof of it. The evidence is insubstantial, unsupported, and in that instance, I would submit inadmissible. The child was sent to a school up in West Virginia for troubled children by her mother. There was an employee there who submitted a declaration that was unsupported in any way. There was no attempt to qualify this person as an expert, so opinion evidence was introduced. We complained about that, and the trial court never ruled on that question. So then we come to the manner of disposing of this, and this is where the statute, this Public Protection Act, runs headlong into the rules of civil procedure. I might say parenthetically the statute says that when there is a denial of the petition or a granting of the petition, that creates an immediate right to appeal. Even though Rule 59 is still available, it creates that demand. So because of that, we had no alternative but to file an appeal to this court and file a notice of appeal. And the defendant moved to quash it, said it was untimely. Well, ultimately, this court did what I would agree was appropriate. It said we're going to follow the rules, and so we're not going to we're not going to dismiss the appeal. We're going to wait until the ruling on the Rule 59 motion, and then that's when and consider the notice filed at that point. I think that's the way it's ordinarily done, has been done for decades, but that's not what the statute says. So when her petition was filed, copious amounts of evidence were submitted, including these videos themselves, in which she states things that only malice can be inferred from it. Anger, said she's never going to stop, characterizing herself as protecting the world from these terrible people. What then are the rules? So you have something that's obviously, in our practice, a summary judgment motion. But there's no ability to do any discovery except by permission of the court. So we had, for example, the inability to bring into court the police officer who had been to the home and who quoted Mrs. Baldwin extensively in his reports. There's no statement of undisputed fact. What is this about? The defendant expressly claimed that they had never filed a Rule 56 motion. So they're filing it under this petition, and the petition we submit plainly usurps, the procedure they use plainly usurps the power of our Supreme Court in creating these rules. Now, in the event that the court were to find that there was material evidence, if that's the standard, or that a jury could find for the plaintiff, if that's the standard, then that petition should have been denied. If that's the case, then this court need not reach any constitutional issue, because that's the primordial question. These proceedings have been rancorous because everything that was said by the defendant was rancorous. She made the statement that my clients could take Gracie to Thailand and traffic her. I don't think there's anything more prominent right now as something to try to shame or embarrass a person than an accusation of pedophilia. This is a hot topic among conspiracy theorists. And I mentioned in the brief, all of us know of the example of Mr. Epstein, who is called a pedophile. It is a standard thing that's employed now to shock and dismay the audience or the public. And that's what happened here. So we have some other technical things. When the trial judge put down an opinion in December, she then instructed Mr. Horowitz to prepare the order. The order is multiple pages. I described it as prolix. It covers all sorts of things, never mentioned by the judge, never mentioned in court or in her written ruling. We submit that order, and she signed it the same day she received it, with a short period of time before we had any opportunity to object to it at all. So, in addition to that, what does this Public Protection Act do to the common law tort of intentional infliction of emotional distress? The argument is that that cause of action is subsumed by this statute if there is a defamation claim. What if we had just filed this case only with that tort? I would submit that under Rule 56 standards, a motion to dismiss would not have succeeded, because we have We have months, we have years of evidence that we've submitted about this. An intentional effort to humiliate and embarrass these people and to do them harm. That's what she did. Now, if we have a order that contains language that the judge never mentioned or assigned, I'd respectfully submit that that's not an order of the court and that can be remanded for that reason alone. But we have plenty of reason. I do not understand, perhaps this is my fault, how it's possible to say that words accusing a person of pedophilia, kidnapping, grooming, all of these things in that context, how this would not be distressing, insulting to an ordinary, reasonable person. Now, if that's the case, and if these allegations are false, and they are, then we stated a case for defamation. The intentional infliction of emotional distress is borne out by the videos themselves. She told them that she was never going to quit. She was going to pursue them, the implication being for the rest of her life, and said that they were running a cult. I would respectfully submit that those things are more than ample to create a jury question. Is that the issue? Is it a jury question? Because the statute doesn't use the rules that this court has applied for decades. It says, is there a prima facie case? Well, there is a prima facie case. You have a statement that's false. Kidnapping, for example, the police and the district attorney in Sumner County refused to do anything further on this when she complained, Ms. Baldwin complained, because they did not find that there was evidence that there had been a kidnapping.
Before your time runs out, let me ask you a question.
Yes, sir.
On this issue about the judge's order, you're proposing that the final order, in the opinion of that the judge actually signed, is not the independent product of the judge? Is that correct?
Yes, Your Honor. It's about 5 times the length of it. It contains findings. It contains judicial recognition of certain facts. It goes way beyond anything that was in the order itself. And we never had a chance to comment on it.
So you're saying that the trial judge did not make these findings from the bench or in any other writing other than...
She issued an opinion in December, and this order was entered in January. She mentioned some things she found in that order that we had not made a prima facie case, but she never explained why. She never gave any reason for it, but she did say that. But there's all sorts of other things. I think, respectfully, the day is going to have to come, and perhaps this is not the case, but we're going to have to deal with this statute and how the courts are going to enforce the law as promulgated by the Supreme Court in the context of this statute.
All right. Thank you, Mr. Blackburn. We'll hear from you on rebuttal.
Mm-hmm.
Good morning, Mr. Horowitz.
Good morning, Your Honor.
Will you be sharing the time this morning?
Yes, the Attorney General will have 3 minutes, and so I will have 12.
So we'll give you 12. Thank you.
May it please the Court, Daniel Horowitz, the Nashville Bar, on behalf of the Appellee, Ms. Theresa Baldwin. I'm here with my co-counsel, Ms. Dix and Ms. Martin. Your Honor, some appeals are lost before anyone reaches this podium. Here, because the appellants have failed to appeal multiple case-dispositive trial court rulings, this appeal is among them. In Buckley v. Elephant Sanctuary in Tennessee, this court held that, quote, where a trial court provides more than one separate and independent ground for its judgment, and a party fails to appeal one or more of the independent grounds, this court must affirm the judgment of the trial court on the ground that was not challenged on appeal, unquote. This court has also issued the same holding in many other cases that are cited on pages 40 to 41 of our brief. Importantly, though, Buckley is a reported decision, so it is controlling here. Judge Clement, I also note that you have cited Buckley for this proposition pretty recently, Halliman v. Austin P. State University, December 2024 case. Judge Bennett, I believe you were on that panel. The rule that failing to appeal an independent ground for a trial court's judgment requires this court to affirm is dispositive of most of this appeal. Let me tell you why. This is a Tennessee Public Participation Act case. At the first step of the TPPA analysis, Tennessee Code Annotated Section 2017-105A, Ms. Baldwin was required to establish a prima facie case that the plaintiff's claims against her were based on, related to, or were filed in response to her exercise of the right to free speech, right to petition, or right of association. The trial court ruled below that Ms. Baldwin met her burden on two grounds. First, based on the right to free speech, and then second, based on the right to petition. On appeal, though, plaintiffs challenge only the trial court's ruling as to Ms. Baldwin's exercise of her right of free speech. Thus, as to the trial court's separate petition-based holding, which was based on the trial court's finding that this lawsuit was, quote, filed shortly after and in response to Ms. Baldwin reporting the plaintiffs to DCS, the plaintiffs have failed to appeal it. As a result, the plaintiffs have failed to appeal a separate and independent ground for the trial court's Section 2017-105A ruling, and that ruling must be affirmed. The plaintiffs have also failed to appeal either one of the trial court's grounds for dismissing the plaintiff's claims under the TPPA. Under Section 2017-105B, the trial court ruled that the plaintiffs failed to introduce admissible evidence to support each element of their claims, thus requiring that they be dismissed. As to that ruling, plaintiffs have listed an issue regarding it, but they don't include any argument on the issue in their brief, so it's waived. Separately, under Section 2017-105C, the trial court ruled that Ms. Baldwin established valid defenses to the plaintiff's claims, thus requiring that they be dismissed for that reason too. With respect to the trial court's Section 2017-105C ruling, though, the plaintiff's brief doesn't mention it at all. For these reasons, the plaintiffs have waived opposition to the trial court's order dismissing this case under the TPPA, and barring some other basis for relief, the trial court's TPPA dismissal must be affirmed. That leaves the plaintiffs with three issues left in this appeal: an argument that the TPPA is unconstitutional, a lakeside challenge, and a claim that the trial court erred by granting sanctions. I will address each of these issues in turn. Beginning with the plaintiff's constitutional challenge, it is waived because the plaintiffs did not timely present it. The plaintiff's argument that the TPPA is unconstitutional was raised for the first time in a post-judgment Rule 59 motion, so the trial court denied it as waived. That ruling was correct. As this court held in Re MLD, quote, a Rule 59 motion should not be used to raise or present new, previously untried or unasserted theories or legal arguments, but that is exactly what the plaintiffs did here. They also do not seriously argue otherwise. Instead, they suggest that they were allowed to raise their constitutional challenge after judgment because courts avoid adjudicating constitutional issues when a case can be resolved on non-constitutional grounds. Your Honors, their position is wrong. Principles of judicial restraint do not permit litigants to hold back constitutional arguments during the life of a case and then raise them for the first time after judgment. Thus, the challenge is waived. I also want to emphasize that the plaintiff's constitutional challenge necessarily fails here even as applied. Plaintiffs have suggested in their brief and today that their claims were dismissed unfairly because they were deprived of some discovery they needed. Your Honors, over our objection, the trial court permitted the plaintiffs to obtain 100% of the discovery they sought in this case. Thus, the plaintiffs' failure to support their claims had nothing to do with the TPPA, and their constitutional challenge fails. Plaintiffs also raise a lakeside challenge, arguing that the trial court's final order was not the work of the court. I will note for clarity that when the plaintiffs refer to the final order in their briefing, they are actually talking about the trial court's TPPA order, not its final order. That distinction matters because the plaintiffs presented a lakeside claim to the trial court below in a post-judgment motion to alter or amend, and the trial court denied it in an actual final order that made clear that the plaintiff's lakeside challenge was factually groundless. At any rate, the plaintiff's lakeside challenge fails for a huge number of reasons. To start, plaintiff's theory of impropriety has changed over time. The claims are also unsupported by the record, and the plaintiffs mischaracterize what the trial court ruled in several material respects. Moreover, the plaintiffs' preferred relief, setting aside the trial court's January 2nd, 2024 order, would not even help them. The reason why is that the plaintiffs do not argue that the trial court's December 15th, 2023 order did not reflect the trial court's own judgment, even though that order, too, held that the plaintiff's amended complaint should be dismissed pursuant to the TPPA based on the same grounds included in its later TPPA order. For the reasons set forth in Judge Usman's recent opinion in Commercial Painting Company versus White's Company, the asserted lakeside deficiency here also would not matter regardless, because the plaintiffs have failed to challenge any of the substantive bases for the trial court's TPPA dismissal, even though that order is subject to review de novo. Plaintiffs' failure to ensure an adequate record on appeal precludes this court's ability to review the issue too, and for all of those reasons, many additional reasons set forth in our briefing, plaintiff's lakeside challenge fails. Turning to the plaintiff's argument that sanctions were inappropriate, the trial court did not abuse its discretion by assessing sanctions here. The trial court's essential finding that sanctions were necessary to deter repetition of the plaintiff's conduct is unchallenged in this appeal. Plaintiff's litigation history against Ms. Baldwin, their vindictive behavior toward her during this litigation, the fact that one of the plaintiffs is a lawyer with a long history of sanctionable misconduct, and the devastating financial and emotional toll that this litigation has had on Ms. Baldwin also support the award. Put that in layman's terms, plaintiffs put Ms. Baldwin through hell. I'll also note that the case for sanctioning the plaintiffs has strengthened since the trial court issued its judgment. One of the central claims in this case concerns Ms. Baldwin's statement that the plaintiffs took Ms. Baldwin's minor child to their bed for prayer time. Plaintiffs have spent years arguing that this statement was false and that Ms. Baldwin owes them millions of dollars because of it. Just a few months ago, though, while testifying during the party's bond hearing, Plaintiff Black admitted under oath that in fact this statement was true. Thus, this lawsuit is premised in substantial part on a true statement that the plaintiffs have spent years asserting was false, including in their brief here. That is a completely unacceptable abuse of the judicial process, and given the $3 million that the plaintiffs placed in controversy here, the plaintiffs are fortunate that the trial court's sanction was as low as it was. For all of these reasons, the trial court's judgment should be affirmed. As explained in our briefing, though, this court need not even adjudicate the merits of this appeal because the plaintiffs' massive briefing deficiencies and their unclean hands, including fraudulent transfers right before execution could commence and perjury, warrant dismissing it. Also note that those arguments for dismissal of this appeal were well developed in our brief, and the plaintiffs did not respond to them, which waives opposition to them. Thus, whether on merits grounds or otherwise, this court should affirm. I do want to hit some of what opposing counsel said in his opening here, that there is a substantial bit of evidence in this record, that there are months and years of evidence. Your Honor, there is evidence from us, but the plaintiffs introduced virtually nothing as reflected in the trial court's order. I heard opposing counsel say that something was inadmissible. Your Honor, there is no evidentiary claim, no evidentiary issue raised anywhere in this appeal. I heard opposing counsel say that an objection to Ms. Maudlin's declaration was never ruled upon. Your Honor, that is simply not true. If you read the trial court's order, you will see the objection was adjudicated. Ms. Maudlin's declaration was admitted for the effect on the listener. The trial court absolutely ruled on the issue. There is no basis for that claim. Heard opposing counsel say that we had moved to dismiss this appeal as untimely. Your Honor, that is not correct. What happened was they filed a notice of appeal, and on the same day, they filed a motion to alter or amend the same ruling. So you had the same issue being considered in two courts. We called that to the court's attention. What this court did appropriately is remand to finish the proceedings down below. After they did, this appeal came up in the normal course. There is certainly no claim that we were asserting that the statute was in conflict with the rules. You just can't appeal and then collaterally challenge the same order at the same time. Heard opposing counsel mention the videos that were submitted. Your Honors, they did not submit the videos into the TPPA record. This is one of many, many problems with the way the plaintiffs litigated this case. The statements over which they are suing are not even in the TPPA record, and they were not admitted. So those aren't there either. I heard opposing counsel mention that they had no ability to bring in a police officer. Let me just emphasize this one more time. They got 100% of the discovery they sought in this case. The only thing that they asked to do was depose Ms. Baldwin. The trial court granted them that relief over our objection. They got all of the discovery they wanted. The TPPA had nothing to do with their inability to support their claims here. If this court has any further questions, I'm happy to answer them.
Hearing none.
Thank you, Your Honor.
Thank you, Mr. Horowitz. Good morning.
Good morning, Your Honors. Aaron Bernard on behalf of the State of Tennessee from the Attorney General's Office. May it please the Court. The state is participating solely for the limited purpose of defending the constitutionality of the TPPA and takes no position on any of the other merits issues in this case. For that reason, as we've heard from both sides, there are numerous non-constitutional issues that can completely resolve this appeal without reaching the constitutional question. Those include the merits of this particular TPPA petition, as well as defendants' arguments relating to briefing deficiencies and unclean hands. Nevertheless, should this panel wish to advance to the constitutional question, the state believes there are at least 3 reasons why plaintiff's constitutional challenge fails. First, it is waived, and the trial court did not abuse its discretion in finding so in the Rule 59 motion. Second, their separation of powers challenge is unavailing. And third, their skeletal invocation of the jury trial right was never mentioned below and was almost directly foreclosed by this court's ruling in Smile Direct Club, which you were the author of, Judge Clement. But speaking now first to waiver, which was touched on before, but as plaintiff's counsel sort of skipped directly to the merits of the constitutional question, it was waived, and the trial court did not abuse its discretion in finding, when it ruled against them in the Rule 59 motion, that they had brought it up for the first time then in that post-trial motion. And it is well established, a rule of Tennessee practice, that new arguments cannot be brought then. In their reply brief in front of this court, they tried to wave at this idea that they had previously stated it in one sentence in their response to the TPPA petition, where they had said they had not gotten procedural or substantive due process because they were supposedly denied certain discovery. And they wanted to make this procedural and substantive due process just to preserve the issue. As we note in our brief, that is a legally insufficient way to preserve an issue for attacking the constitutionality of a statute, as the Tennessee Supreme Court held in adoption of In Re ENR. You must give notice to the Attorney General's office if you're going to fully make a constitutional challenge to a Tennessee statute, as well as you cannot just simply say, I'm preserving the issue, that's all, and not fully develop the argument. So when the trial court below said you did not fully raise and develop the argument, that is an opinion, that judgment can be completely affirmed if the court would like to reach that question at all, but can completely address it on non-constitutional grounds. Just a moment as well to address the merits of the constitutional question. They bring up the Welliford case in their reply brief, where they say that there is a conflict with the Welliford case, but in that case, that had to do with a complete destruction of discovery and disallowing it completely, where here, discovery was granted, and it was done so sua sponte by the district court, so there was absolutely no clash in the TPPA. If the court has no further questions.
Hearing none.
Thank you, Your Honors.
Thank you, General Bernard. Mr. Blackburn, your rebuttal.
May it please the court, the law is clear that a court will not deal with a constitutional issue if it can address it in the merits of the case. How we address it in this case is confused because the statute says that you just submit affidavits or other evidence of that type. There's no oral hearing. That means it should have been a Rule 56 motion. However, in the order of July 11, 2023, the trial court said the plaintiffs have argued that the defendant's deposition is necessary because they assert that the defendant tendered the hearsay testimony of a purported expert from another state, that Ms. Baldwin insists that plaintiffs must essentially try the case through affidavits, and because the plaintiffs take issue with the constitutionality of the Tennessee Public Protection Act. It was our clients who were saying that about the affidavits. That was just a typo. We had raised, I think, 8 issues on appeal. I'm not sure where the idea that these videos were not in this record comes from. That's why the record is so voluminous. Those were filed initially in response to the initial petition. The videos are there. There are also direct quotes from the videos that have not been rebutted whatsoever. And the essence of that part of the appeal is that the things that she said, Ms. Baldwin said, were not supported by any admissible evidence, just her opinions, and that she made accusations about pedophilia, kidnapping, and so forth. I don't believe she denies having done that, and that these things are offensive to an ordinary person. That's the essence of the defamation claim. That is the defamation claim. Now, with regard to I'm surprised to hear an experienced lawyer tell you that sanctions should be imposed by the number you choose to place in your addendum clause. As the court knows, that puts a cap on the amount a jury might be able to return, but it's not evidence of anything. The relief that she should have sought, if the law were applied, would have been malicious prosecution. She never filed a claim for malicious prosecution. As you know, that claim doesn't arise until the underlying claim is dismissed. You got to prevail on that first. This is imposed as a sanction for having filed the lawsuit. Now, what happened you could take a whole other argument on the bond application, but that application, at the time it was made, there was a conveyance made by quitclaim deed as part of an estate plan, which the plaintiffs contend did not shield this property from execution. Nonetheless, they conveyed it back before that hearing occurred. This is a matter of law. This is not a clean hands matter. Afraid my time has expired. Thank you.
Thank you, Mr. Blackburn, Mr. Horowitz, and General Bernard for your arguments. We'll take this matter under advisement. Call the next case, please.
Debbie Williams